Are you Mr. Hanna?
Yeah.
All right. This is case number 2024 CR 420, State of Kansas versus John Hanna. Mr. Hanna, it looks like you've been charged with one count of sexual battery. That is that's a Class A misdemeanor. That can carry up to a year in the county jail and a fine of up to $2,500. So let's talk about how you might want to handle your case. This is just the time just to let you know what your charges are. Did you get a copy of the charges against you?
Of course not. I haven't even been found guilty on the sanction, the write-up while I'm in here.
Well, of course you're not going to be found guilty yet.
But I mean, I don't mean to interrupt you, but that's the procedure. And I mean, we could talk to the Department of Justice about the jurisdiction of the case as well. We can take it to that extent, but you can go ahead and continue. I would like to challenge the jurisdiction on the charge. I want to state that for the records as well. Will you continue? My apologies.
And here it comes, the classic sovereign citizen move. I challenge jurisdiction. It's almost like a script at this point. The problem? Jurisdiction is one of the very first things established in court. If you're physically present in that courtroom and the crime happened in that state, the judge has jurisdiction, period. There's no secret loophole or magic phrase that makes charges disappear. But notice how calm the judge stays here. He doesn't bite. He doesn't argue. He just keeps moving forward because engaging in this debate would only drag the case into chaos.
Mr. Hanna, I'm going to run this court, not you. And you can start off with this sovereign citizen crap about jurisdiction and everything else if you want to.
I'm saying, I understand that. I'm just saying, but
it's not going to
charge
get
the Department of Justice as well, because you know who the director of the Department of Justice is, right?
That's just fine. You can do whatever you want.
We'll to him now.
Anyway,
he'll be waiting on an indictment on you.
In any event, you're charged with one count of a sexual battery, Class A misdemeanor. You're going to have an attorney to represent you, or do you want the court to appoint somebody to represent you?
You can appoint me one, and I'll have an attorney later on.
This is exactly how a judge should handle chaos, firm, direct, and without wasting time. Mr. Hanna is already juggling prior convictions for aggravated domestic battery, aggravated escape, and more. Add sexual battery against a deputy to the list, and the picture gets ugly fast. The state recommends a $7,500 bond, which honestly feels light considering his record. Here's a key takeaway. In bail hearings, your criminal history matters just as much as the current charge. Judges aren't just weighing today's crime. They're looking at your entire track record when setting bond.
A hearing date on the misdemeanor control docket. Your next hearing is going to be November 18th at 9 o'clock with Judge Webster. That can be by Zoom. Mr. Canfield, what's the state's recommendation on bond here?
Your Honor, in addition to the sexual battery against a deputy, the defendant also has been convicted of aggravated domestic battery, aggravated battery, and aggravated escape from custody. So at this time, the state's recommendation will be a $7,500 cash or surety bond.
Those charges aren't even my record. For legal detainment and
very well, the court's going to go ahead and set your bond at $7,500. 30.
Maybe facing the grand jury.
If you can, sounds like you can afford your own counsel, so I'll let you go ahead and see about doing that. If you can't afford it, when you get around to your next hearing, you can ask the judge to appoint counsel for you. But I've given you your next hearing date. You know what your bond is. You'll need to stay with the sheriff until such time as you are able to execute your bond.
And so we didn't address the jurisdiction issue either, right?
The fact that you're where you are and I'm where I am means that I have jurisdiction.
And here we go again. Hannah insists jurisdiction hasn't been addressed, even though the judge just explained that being in custody in the state is all that's needed. Sovereign citizens cling to these pseudo-legal arguments, but courts don't have patience for it. The irony here? By continuing to argue, Hannah is only hurting himself. Judges take note of your attitude, your cooperation, and your respect for the process. Acting combative during a bond hearing is basically volunteering for stricter terms.
Be on the record in Hannah 2024 CR 420, State of Kansas versus John Raymond Hannah. Jared Regier for the state, defendant pro se, but does John Hannah appear? Again, I called a while ago and no answer, so John Hannah fails to appear. Mr. Regier, recommendations on a sexual battery charge dating back to August 30th, 2024.
This right here is the moment everything flips. Hannah fails to appear, which is basically the cardinal sin in court. When you miss your hearing, judges have no choice but to issue a bench warrant. His bond is forfeited, and just like that, his $7,500 bond balloons into $15,000. Think about it. He was already claiming the court had no authority. Now, his actions are proving to the court that he can't be trusted to follow orders. That's a recipe for disaster in any legal system.
The defendant was to make a $7,500 cash or surety bond, although he was very combative and challenging at the time.
Your Honor, I do have some notes from the initial hearing on September 6th before Judge Sanders that would appear to at least marginally refer to what the court is referring to insofar as the defendant's attitude at the first hearing was concerned, or perhaps demeanor is a more appropriate term for it. I do not have anything in my file insofar as an appearance bond is concerned. Perhaps the court knows something that I do not know, but I am not showing any affidavit from the jail either.
I am not showing anything in the file concerning the bond, although I'll check my queue real quickly and see if it's something that might be in there. Well, I'm not seeing it, but yet I don't know how I could have gotten out of jail without making a bond.
And my notes do appear to suggest that that the defendant did appear in custody. To cut it to the quick, Your Honor, the state will be recommending, based off of the amount of the bond and the charges before the court, at the very least $15,000 cashier surety or no bond hold, depending on which way the court determines is appropriate. The state would also defer to the court as to whether a bench warrant or a bench bond forfeiture should be the court's order at this time.
Well, I'm going to issue a bond forfeiture, but if he didn't post the bond, then of course we can't enforce it. But I'm ordering a bond forfeiture. I'm ordering a bench warrant for the failure to appear, and the new bond will be set at $15,000 cash or surety.
Thank you, Your Honor.
This is where things get wild. Hannah didn't even post bond. He was simply released by the jail. How does that happen? It's a clerical failure, plain and simple. But here's the kicker. Sovereign citizens love to argue the system is broken, and this mistake plays right into their narrative. Still, a mistake in procedure doesn't erase the charges. And let's be real. Does anyone honestly think a guy who denies the court's authority is going to show up voluntarily? Doubtful.
We are on the record in 2024 TR 617. Sir, you may need to scoot over a little bit to be picked up by that microphone. I'm not sure, but sometimes you have to be in the middle with it. Mary Ann Shirley appears for the state. Are you Abel Estrada Jr., sir?
Yes, if I may, can I make a statement?
No, not yet. Okay, sir, you are charged in count 1 with on or about the 21st day of August, 2024 in Greenwood County, state of Kansas. Then and there, contrary to the statutes of the state of Kansas, unlawfully operating a vehicle, to wit, a 2011 GMC Acadia, upon a highway which.
And now we meet the second sovereign citizen of the day, Mr. Estrada, who's bringing out the infamous straw man defense. For those unfamiliar, this is the idea that your legal name in all caps represents a fictional corporation the government owns, and you, the living man, aren't subject to laws. Spoiler alert, courts do not recognize this nonsense. On top of that, he's claiming double jeopardy, but here's the truth. Double jeopardy only applies if you've been tried and acquitted or convicted of the exact same charge. Since the original case was dismissed and refiled in the proper court, there's no violation here.
Have the signed license plate. I think they mean that the vehicle didn't, not the highway, but your vehicle did not have the assigned license plate properly affixed to the rear of the vehicle, showing the current registered year. And this is an unclassified misdemeanor. It is punishable by up to $2,500 in fines and a possible sentence of up to 6 months, 30 days minimum, up to 6 months, although probation is usually granted. Now, sir, did I not just have you in municipal court recently on the same charge?
Yes, and I don't understand why am I seeing again, because that would be double jeopardy. I'm saying for the same.
Well, sir, you haven't been tried on it. You
I have,
had a first appearance on it, and
I have-
apparently the city prosecutor must have dismissed it and refiled it over here for whatever reason, I know not. But as I recall, your plea was not guilty. Is that still your plea?
yes, but I'm here to make a separation between my name. My name is Abel Estrada with low caps. This name on the top, I don't know if you can see it. This name on the top is my straw man. I am the man, and this is the straw man. So if you're calling the straw man, I'm here to represent the straw man, but I'm Abel Estrada Jr., the man, the living man.
I'm calling the living man.
So I
So are you going to have an attorney? Are you going to need to apply for court-appointed attorney, or will you be waiving your right and representing yourself?
no, of course, I wanted to run an attorney, but I still haven't not made my statement, which is,
Are you going to hire an attorney or apply for court-appointed?
I cannot afford an attorney, but I need to make my statement that,
Let me get a few things worked out, sir. You're going to apply for an attorney, so you'll need to fill out an application for court-appointed attorney, and the deputy down there can give that to you. Make sure you fill that out and get that back to me before this hearing is over. Make sure you fill in all the blanks and you sign it and you date it where it says to, because I generally don't consider those if they're not thoroughly completed. And then you call back to my assistant, Missy, later in the week to see if one is appointed and who that will be. Do you need Missy's number, or did you take it down earlier from the other hearings?
no, I don't have.
All right. Missy, do you want to give him your number?
620-583-8155.
And then Missy, when is his next court date?
Well, I haven't explained my position.
Sir, we're not going to have a trial today. You're going to need to talk to your attorney before you have a trial. So Missy, when is his trial date?
I wanted to move,
Sir, please do not interrupt. Missy, when is his, and we won't set it directly for, do you want to set it directly for trial, or do you want to set it for a status so I can
I
check
don't
in with you after you talk to your attorney?
I don't know what the status means.
Well, let's set it for a status, Missy, or control.
November 22nd at 10.
You, sir, will need to be back here by Zoom November 22nd at 10 a.m. Are you on bond? Let me check.
Why would I need a bond?
Complaint from the cause. There is no bond on the file, and it is an unclassified misdemeanor. So I'm not going to make you file a bond since it's an unclassified misdemeanor. If you fail to come to court, though, most likely a warrant would be issued anyway, and you'd be taken into custody. But as long as you come to court when you're told to, that's not going to be a problem. So you're going to call and get your attorney, or find out if you have an attorney.
I haven't given a chance to
You do not need a bond, and you have your.
This is textbook sovereign citizen behavior. Talk over the judge, flood the court with pseudo-legal jargon, and then claim your rights are being trampled when nobody takes it seriously. But here's the reality. He was given multiple chances to speak, file proper motions, and get legal counsel. Instead, he's trying to turn the courtroom into a stage. Judges have seen this time and time again, which is why they respond with patience but zero tolerance for disruption. The longer Estrada drags this out, the more he risks making his own situation worse.
I want to move to a motion to dismiss this case because I didn't try for this, and I have the license plates, both license plates. I was not driving anything unlawful or illegal. I'm living in the private. I'm driving in the private, and so I want to move for dismissal with extreme prejudice. And also, I want to make sure that you understand that I want to keep all my constitutional rights. So far, my constitutional rights are being trampled over right now by yourself because you're not giving the chance to speak. I have not given the chance to speak. You're just going over and over. And I'm requesting that you remove this case because this is double jeopardy. I already appeared in court. I already suffered the court. I have not been given the opportunity to explain myself. I want to keep my rights, and I haven't been able to keep my rights. You yourself and the lady on the other side signed a oath of office to uphold the Constitution of the United States, and I'm not being given those rights right now, man. I respectfully request that you honor my rights. And I want to move for a complete dismissal because it's double jeopardy and I already appeared in court.
All right. Well, I did give you the opportunity to speak. You were speaking, not I, not Miss Shirley. And so I gave you the chance to say what you want to. If you want to talk to your attorney can help you put together the motions that you've kind of implied, at least, if not outright said you want to pursue. But we will take that up on the date that I gave you to reappear.
I'm sorry, it's breaking up. You said you're going to take what up to do what?
I can take up any motions that you want to file at a later date. With the next court date, we can revisit any motions or visit any motions you want me to consider.
I appreciate it. Thank you.
You're welcome.
Being dragged on so much, and I have a hard time moving around. As you can see, I'm disabled, and I only come here once a week to the hospital to be treated, and all this court is putting a lot of stress, and I'm not able to heal properly. Why are we dragging it out so much, ma'am?
When did you get this disability? I don't remember you being unable to walk the last time I saw you.
I came in my bike is right here. I have it right here. I don't know if you can see it. But I normally use a walker in a wheelchair, but I'm using the other one because it's easier to carry in the car. It's what's it called? It's knee scooter. I have 2 amputations on my feet. So ambulation is very difficult. I'm having a lot of pain. In fact, I'm under medication right now. I don't have a can be here because it's too painful.
Well, that's why you need to call back here. You don't have to come in person. Call back here or have your wife or helper, whoever that is with you, call for you, and Missy can tell you if you qualify for an attorney and who that attorney will be and how you can get a hold of that attorney before your next court hearing. We did give you the date of that court hearing. You will need to be back here for that, but you can do that by Zoom. You don't have to even leave your home to do that as long as you've got a clear signal that allows us to communicate. So I mean, you're always welcome to come down there to the courthouse like you're doing now, but you don't have to as long as you can communicate by Zoom. And remind me, what town do you live in, sir? Are you from Kansas?
Yes, I'm in Howard. But even last night, when I got the letter from the sheriff, they brought it to me at 5 o'clock last night. I didn't even know.
All right, well,
So it wasn't improperly served. I got it like literally last night. We're trying to get paperwork come in, and I don't have the time. I don't have the ability to move that fast. And so
well, you were just complaining a moment ago that this case wasn't moving fast enough, that we were dragging it out. So there you go. Move it too fast, you say.
Yes, but it's dragging on because
And here's the irony. Estrada insists he needs an attorney, but every time one is assigned, he rejects them because they don't follow his laws. This is the fatal flaw of sovereign citizen logic. They want the protections of the justice system without recognizing the system itself. Attorneys are bound by real law, not the defendant's personal version of it. That's why his public defender asked to withdraw, because Estrada refuses to cooperate and insists on running his own fantasy courtroom. It's self-sabotage, plain and simple.
To withdraw from this case.
Your Honor, Mr. Estrada filed pro se, I do believe. Well, I know it was pro se filing.
Well, I do notice he's taken a number of filings in his own right without going through counsel. Mr. Estrada, you come back to my recollection, we've met in city court, correct?
yes.
And now this is that tag and suspended license?
No.
No,
It's a tag issue, Your Honor.
Just the tag, Your Honor.
All right.
I believe Mr. Paul is requesting to withdraw based upon the essentially sovereign type citizen claim filed by Mr. Abel.
Well, let me,
Mr. Estrada, excuse me.
And also, there's been a total breakdown in communications, Judge. He files his own motions. I cannot represent him.
he's okay. All right, Mr. Estrada, you were appointed an attorney. Apparently at one point you wanted one, or maybe we gave you one and you didn't want one.
No, that's not it.
Excuse me?
I'm sorry, that's not it. He's not, Richard Paul is not seeking my interest, and I put everything in an affidavit. He's not representing me. He's actually judging me before, he's judging me before I even go into court. He's not listening to my paperwork, so he decided he doesn't want to represent me. So I still need to be represented.
Well, Mr. Paul, you're allowed to withdraw.
Thank you.
You're welcome. Is this the last case you have on the docket?
Until 11, Judge. I have an 11, so I'm just going to mute myself and.
That'd be fine. All right. Now, I think you are going to have the same problem with any other attorney that you had with Mr. Paul. Mr. Paul, from this court's experience over the years, is a very competent, diligent attorney. Now, sometimes attorneys have to tell you their opinion of what's going to happen. And you may or may not agree with their opinion, but you do still want an attorney.
I do. I do need an attorney because I don't know how to defend myself with this court. And also, I have a thread of the communications that you can see it. And I'm not getting represented correctly. I'm sure he's a competent attorney, but I proceeded to give all my information, all my laws, and he doesn't.
Your what? Your laws?
The laws, the Constitution.
Your Honor, Your Honor, could I say
Please.
something, please? Mr. Estrada, every attorney who the court can appoint to represent you, one, I don't want to see, and I'm sure the judge is the same way, I don't want to see any kind of communication thread between yourself and Mr. Paul, because there could be confidential, well, I'm sure there's confidential and privileged information within that, and you shouldn't be disclosing that to me. That's between you and any attorney you so choose to have represent you. But I believe most attorneys, or all attorneys that the court has available to appoint to you, they are sworn to uphold the Constitution of the United States and the state of Kansas, and not what you filed. That's the attorneys didn't go to your law school, which is kind of what you've set forth. So that's the issue the court's talking about when you're claiming a sovereign citizen. We don't have an attorney who's, I guess, registered to under your rules and laws as you see them. So that's the problem you're going to be running into as far as the attorneys the court has to appoint to you. If I said that correctly, Your Honor.
Thank you, Mr. Dean.
I'd like to say that I'm not a sovereign citizen. I'm just an American, and I'm just being constitutional, and I'm not doing anything. I'm not breaking any law. He didn't see all my paperwork. He just ignored it. He just blew through it, and then gave me the wrong dates. I presented all the documents, and he didn't even look at it and ignored the paperwork.
All right, and let me ask you this. You are wanting a trial on this illegal display of a license plate or failure to display, right?
Well, no, I'd like to address, I'd like to first, if we possible, we can a motion to dismiss with the street.
We're not going to do that today. All right, I'm going to one more time appoint you an attorney.
Your Honor, could I make a request to the court on this matter?
Sure.
This case carries a maximum sentence of 30 days. Doesn't even have an eligibility or requirement that he be provided an attorny.
Well,
I'm just.
There's
just
potential jail
like
time.
I would like to have if the court wants. I understand if the court wants to appoint an attorney. Absolutely, don't dispute that. But under the circumstance of the defense that's wanting to be presented, I would ask the court to appoint somebody. I get Mr. McClendon is still available.
That's just what I was thinking. He's here in town.
We set this next hearing, give sufficient time, perhaps 60 days, perhaps longer, and we just have it set for a bench trial. And if he doesn't want to cooperate with that attorney, the state would be asking for the court to proceed to trial, whether or not he can get along with the second one or not.
Well, it seems we're on the same page of thinking, counsel.
Mr. McClendon is in the waiting room.
Mr. McClendon.
I can bring him in.
Bring him in. You're in Howard. He's got an office here in Eureka.
Mr. Estrada believes in Wichita. You're
I thought didn't you tell me you were in Howard?
I'm in Howard.
No, my mistake. That might have been on one of the notary stamps.
Well, you let Kit Collins in. Does Kit Collins want an appointment?
Oh, no, Judge, I just let all the 11 o'clocks in.
Okay. Mr. McClendon, could you join us for a moment? Were you in city court the night that Mr. Estrada, the gentleman under Motorola, had the tag violation?
Yes, Judge. You pointed me to his case briefly, and then Mr. Watson and I had a discussion and figured it would be more proper for a district court case.
Will you take the appointment if I give him back to you?
I guess, Judge.
So what did we just witness? Two self-proclaimed sovereign citizens, one facing serious criminal charges, the other fighting a traffic case, both trying to bend reality inside a courtroom. Instead of focusing on actual defenses, they relied on arguments that judges have heard and rejected 1,000 times before. The results? Higher bonds, bench warrants, frustrated attorneys, and zero progress in their cases. The lesson here is simple. Courts run on law, not loopholes or internet conspiracies. What do you think? Should courts crack down harder on sovereign citizens who waste time, or is patience the better approach? Drop your thoughts in the comments. And if you found this breakdown as shocking as we did, hit that like button, share this video, and don't forget to subscribe for more jaw-dropping courtroom moments every week.